appeal are heard in the matter of InterDigital Technology Corporation and others, and Lenovo Group Ltd and others.
Yes, Mr. Garland. Well, Lords, my lady, I now come to something that I refer to as the Pozzoli/prejudice point. My learned friend calls it the Pozzoli principle. My learned friend did use the word prejudice in his grounds of appeal in the skeleton, but the oral submissions seem to have changed the emphasis slightly, and it's now about being some alleged common general knowledge to the effect that on-off keying was thought to be impractical. But my learned friend did rely on what he presented as being the Pozzoli principle. And first of all, bearing in mind that it might be less familiar to my Lord Justice Warby, my Lady Justice Falk, what this principle actually is, I'd like to explain what it is, and in particular point out that it's no longer what my learned friend said it was. There's been a subsequent decision of Mr. Justice Arnold, as he then was, which I drew to my learned friend's attention 2 days ago before this appeal started, and we're handing that up in a moment. But let's start with the Pozzoli itself. For this one, I invite my Lord and my Lady to go to Authorities, tab 3. And in this, the case is most often cited for a slightly different purpose, the approach to obviousness generally. The passage of relevance for present purposes is paragraph 24 on page 47, which is headed Obviousness, Lines in the Path and Paper Tigers. It's more patent law jargon there. It's important to bear in mind none of this changes the single question of fact. It's simply a label which is applied to a particular type of case, which is relatively rare in practice. When I say a label, it's the label about lines in the path and paper tigers.
It seems to have been Mr. Carr who came up with lines in the path.
It was, yes. And then we've had paper tigers, and this Justice Man came up with a small yapping terrier. Further refinement. But yes, these are the things that entertain us in the dawn and dusty fields.
You have to have something to revive the tedium.
But returning to the tedium, it's merely a label, as I say, and the starting point in the particular type of case where this matters is that the claimed invention is obvious over the prior art, and the patentee seeks to defend that. Can I suggest what I mean by that? If Samsung suggested the use of on-off keying in its claimed method, one counter might have been, oh, the skilled addressee reading Samsung would not have expected on-off keying to work, or at least not in that context. But that was never our case, because we never needed to deploy that counter. Ours was just the normal type of obviousness case, where the question was simply whether the claimed invention is obvious over the prior art in the first place. Now, I'll make that good by going through paragraphs 24 to 29 at some speed, because Elena Friend did this once already. Paragraph 24 is where Lord Justice Jacob stresses that it's the patentee seeking to defend his invention from a charge of obviousness by saying there was a technical prejudice against it. So it will be something for us to raise. And then next, Lord Justice Jacob refers to the intellectual oddity about arguments based on this in paragraph 25. And the oddity is, as Lord Justice Jacob explains, that you must have the idea first. It says that halfway down. You can't reject an idea technically unfeasible and practical unless you've had it first. And if you've had it first, how can the idea be anything other than old or obvious? So the first step is to have the idea, and I'll come back to what's meant by the idea. But having the idea is either old or obvious. So the patentee's counter is to bring the prejudice into play once you've had the idea, and the prejudice, the technical prejudice, causes a skilled addressee to dismiss the idea. And then Lord Justice Jacob goes on to consider when patentability would be justified in a situation where you have these two competing factors. And it's simply this, that in paragraph 27, the patentee has contributed something new and inventive, which is not just the obvious idea, but showing that it works. And in paragraph 28, the patentee has merely had the obvious idea without showing it works. Now, I'll come to the particular way paragraph 28 is expressed in a moment, because that's the subject of the subsequent decision by Mr. Justice Arnold. But at any rate, both of these are situations where the relevant idea was obvious, and that's the key feature of a prejudice type of case. Now, I will hand up this decision. I'm going to hand up two decisions, both of which are indicated below. I'm only looking at the Dyson one now. We have, I hope, a sufficient number of copies of that, and the other goes to the secondary ground of appeal, and my lords and my lady can put that to one side. And the case of Mr. Justice Arnold, it then was, is Dyson and Samsung. We don't need to worry about the head note on the facts. All we're going to is what Mr. Justice Arnold then was said about the passage of Pozzoli I just read out. And we can get this starting at page 663, paragraph 153. Says, in considering where an invention is technically obvious, it may sometimes be important to consider whether the addressee would have prejudice against taking a particular step. And then skipping to 154, more recently in Pozzoli, Lord Justice Jacobs said, and then there's an extract of the paragraphs that my lords have been taken to know twice. And it's particularly paragraph 28, where Lord Justice Jacob had said, where, however, the patentee merely patents an old idea, thought not to work or to be practical, and does not explain how or why, contrary to the prejudice, that it does work as practical things are different. Just stopping there, para 155, Mr. Justice Arnold records that counsel for Samsung recorded the sentence I've just read out, first sentence of para 28, is no longer good law. Over the page 156, counsel for Dyson accepted that Lord Justice Jacobs' wording required some adjustment. He submitted that although it was not necessary for the patent to explain, quotes, how or why, contrary to the prejudice, that it does work and is practical, close quotes, it was necessary for the disclosure in the patent to make it plausible that the invention would work or be practical, contrary to the prejudice. And there's a reference to speech of Lord Hoffman. And para 157, I accept the submission of counsel for Dyson. Subject to the writer, I do not believe the patent must expressly address the prejudice, although a failure to mention any prejudice in the specification may be of evidential significance. So the upshot of this is that it's not necessary for the patent to explain how or why, contrary to the prejudice, that it does work or is practical, contrary to any suggestion that an friend may have made to that effect. What is necessary is plausibility. And of course, plausibility was never an issue in this case. It was never disputed. The patent was plausible. It was Milena Friend's case. It was not merely plausible, but obvious. So that's the principle. But how does it apply to the present case?
Mr. Campbell, did this case go on appeal?
Not as far as I know. No. In fact, I think Mr. Justice Arnold himself subsequently referred to it in another case,
Right.
which was Teva and some, might have been Teva and AstraZeneca. I don't know if that was first instance of appeal either.
Okay, thank you.
But anyway, I'm inviting this court to follow Mr. Justice Arnold's example. We're now turning to how does this apply to the present case, and my submission is it simply doesn't. I told my lords and my lady that it's important to be clear on what you mean by, quotes, the idea. And the only idea which matters, the idea which Milena Friend wants to show is obvious in order for his case to get off the ground is the claimed invention. That's the idea. And it was never our case that the invention was obvious in the light of Samsung, but there was some technical prejudice that it wouldn't work or be impractical, which is precisely what His Honour Judge Hacon said in paragraph 147 when dismissing this very argument below. I took my Lords to that passage, paragraph 147, yesterday, and that's why we say the judge held, and correctly held, that the principle identified by Leonard Friend doesn't get off the ground. It was not that sort of case. Leonard Friend also mentions in his written submissions a case called Azaztec, which is one of, rather, Phillips in Azaztec, which is one in which he was involved. But Leonard Friend ran a very similar argument in that case, and it never got off the ground in that case either, for the same reasons that the judge held, and I invite this court to affirm. It never gets off the ground in the present case. And I'll demonstrate this briefly by reference to Authorities tab 6, which is Phillips and Azaztec. Now, I'm going to go straight to page 183 here, because again, the facts don't matter. That's the point of principle. And in this case, at paragraph 59, it's the judgment of Lord Justice Floyd, with whom Lord Justices Henderson and Patten agreed. It cites out a passage from Pozzoli, but the court in that case was able to dismiss the point quite quickly, as I'll now demonstrate. So after citing out the passage, which is 25 to 29, paragraph 60, Mr. Hinchliffe sought to rely on this principle in the present case by characterising the judge's conclusion as including the finding the skilled person would put off the obvious idea of moving the implementation of SHAD to the base station because of the implementation and performance issues found by the judge. I shall need to consider whether this characterisation is correct. Now, paragraph 60 doesn't use the word, or rather the phrase, technical prejudice, but it does refer to this principle in line 1. And given that we've just had the quotation from Pozzoli about technical prejudice, the principle was indeed the principle of technical prejudice. So it's very similar to the argument Leonard Friend advances in this case. If we go to see how Lord Justice Floyd dealt with this, he didn't accept that characterisation, and that's at paras 73 to 74. And in paragraph 73, we see an argument which is very similar to the argument in this case, as follows. Finally, the defendants contend that the issues which the judge held would have deterred the skilled person from proceeding to implement SHAD at the base station remained issues for the implementation of the 525 patent, in the sense that the patent did not teach the skilled person how to overcome them. This is the point based on the passage from Pozzoli, which I've cited above. The principle is you cannot have a patent for doing something which the skilled person would regard as old or obvious, but difficult or impossible to do, if it remains equally difficult or impossible to do when you've read the patent. To put it another way, the perceived problem must be solved by the patent. I do not think this principle avails the defendants in the present case. On my reading of his judgment, the judge did not accept that the idea of implementing SHAD at the base station was on its face obvious. The judge concluded the skilled person would follow up SHAD's proposal to optimize his algorithm. I would not be prompted to think of alternative ways of implementing it. The argument therefore doesn't get off the ground. Secondly, the judge deployed the difficulties involved in implementing SHAD at the base station as a legitimate means of testing Mr. Gould's evidence that the idea of implementing it there would readily occur to the skilled person. He did not fall into the trap of placing imaginary lions, some call them paper tigers, in what was otherwise an obvious path. So Azaztec wasn't an example of a case where the claimed invention was obvious, but the patentee relied on a technical prejudice to counter that. It just never got off the ground, in the same way as we would say the argument in this case. And Valera friend is right. It follows that every obviousness case is in fact about technical prejudice. And all of the arguments against obviousness are in fact arguments which rely on technical prejudice, even if the patentee doesn't rely on a technical prejudice, and the judge makes no findings about any technical prejudice. And if that's right, then the test for obviousness is no longer the simple question as identified by this court in Medimune. In every case, it now comes festooned with complications about the need to show that technical prejudices have been solved. And apparently these complications still apply, even as the invention is not obvious, according to the simple question. Now, what was our case then? If we'd had a case of technical prejudice, then the simplest way for Valera friend to demonstrate that we had such a case would have been to go to our closing submissions, which are in the bundle at our request, supplementary bundle. But Valera friend never went to them to show my lord and my lady where we said anything about technical prejudice. And I will go to them in a moment. But Valera friend's best shot at suggesting that we positively relied on evidence that on-off keying had disadvantages was a passage from Dr. Moss's third report. Now, there are two answers to that, a long one and a short one. The short one first. The short one is the judge dealt with all this evidence in paragraph 70 of the judgment. That's the one about coherent and non-coherent on-off keying. And the judge did not find that there was any perceived, as it established any perceived disadvantage of on-off keying. And the judge did not make any finding that it was generally understood that on-off keying was impractical or would not work. My Lord Justice Birss observed yesterday at page 75 of the transcript the judge's comment about on-off keying being seldom used, having features that mean you might not choose to use it in a given situation. It's not the same as saying it was thought not to be practical. And I noticed that my learned friend accepted yesterday. He did take you to Dr. Moss's evidence, which is discussed in paragraph 70. My learned friend accepted that the judge didn't make an express finding in this respect. That's page 81, lines 4 to 6. And it's my learned friend who invites this court to make a finding for the first time via a process of island hopping that there was some common general knowledge perception that on-off keying was impractical and would not work. That's the short answer. The longer answer, unfortunately, involves looking at the islands. And they're recently rediscovered islands at that, by which I mean they're the ones which were added to the Court of Appeal bundles just this week, in fact, pursuant to an application made last week. And the reason why you resisted the application rather than consenting to it was for precisely this reason. It is an attempt to make a fresh finding of fact. Now, in order to demonstrate why it doesn't help my own friend anyway, I need to show to my lord and my lady that the new materials added to the bundles didn't, or at least the materials of which my lords and my lady were taken, didn't extend to the point to which Dr. Moss was replying in his third report. I need to take a little bit of time on this, but I'll try and do it fairly quickly. If we go to Professor Valenti's second expert report at sub 5, page 55, that's the table of contents in Professor Valenti's second report. And we see that the section of invalidity starts at page 8 pages 8 to 21, sorry, 8 to 26, are all about Leroy. That's 18 pages, and Samsung are pages 27 to 36, which is 9 pages. And that reflects the nature of the case below, which is much more about Leroy. If we go to the next page of this bundle, which is 56AA at the bottom, paragraph 48, just to orient the court. This is where Professor Valenti is talking about integers 1D and 14D. But this is all in the context of Leroy. And the case on Leroy, so far as integer 1D was concerned, was anticipation, because Leroy, the pleaded case was Leroy did anticipate integer 1D. So that's the context, different prior art, different legal issue. And in paragraph 52, Professor Valenti is responding to paragraph 189 of Dr. Moss's first report about whether the fixed signal in Leroy, the reference to that, was a coded predefined message. Now, Dr. Moss had given a number of reasons for holding that belief, and I'm not going to go there, that's going too far. But that was the context in which Professor Valenti was getting onto this topic at all. He was replying to Dr. Moss's evidence about Leroy. Now, paragraph 53, Professor Valenti deals with Dr. Moss's first reason for reaching a particular conclusion about Leroy. Then paragraph 54 is the second reason. And then we come to paragraphs 56 onwards, where we see that Professor Valenti is contrasting the use of on-off keying with binary phase shift keying. He does that in words in paragraph 56. And his argument was that if you've made a decision for the transmission of a single bit of information, and that was the primary case, there are theoretical reasons, or at least probes, to favour on-off keying over BPSK. But Dr. Moss had explained that another motivation for using a coded message in Leroy was the need to avoid misinterpreting a coded message. That's paragraph 57. And that's what led to Professor Valenti making the point in his paragraph 57 that the error rate of a binary signal was merely a function of the design of the signals and how the decision threshold is set. That's lines 3 to 4 there. And he then created the figure O we see on the next page in an attempt to suggest that on-off keying could give results as reliable as those produced by BPSK if you either transmitted for a longer time or increased the transmit power. And we see that from the top of that page 56BA. Now, the figure O hadn't appeared in any of the case papers or in any of the contemporaneous documents or even his first report, which is why he had to create it. But the whole significance of this, the punchline of this whole line of evidence, was that according to Professor Valenti, increasing the transmit power was expressly disclosed by Leroy. And that's something my lords and my lady will see about 8 lines up from the bottom in paragraph 59. So the only reason we went down this line in the first place was all because Professor Valenti was saying, well, yes, there are pros and cons, but you could overcome the con if you increase the transmit power as suggested by, as expressly disclosed by Leroy. Now, he also goes on to say whether this was acceptable depends on a number of things, like were the relevant bits equally likely. Of course, it would also depend by how much you need to increase the transmit power. But all of this was in the context of Leroy and its disclosure that you could increase the transmit power. So now we come back to where my learned friend went, which was SUP 4A. And if we just look at 53CA, we'll see that Dr. Moss has a section on Leroy starting at page 4, Samsung 3 or less than 3 pages starting at page pen. And if we go to 53D, page 53D, and this was a passage which my learned friend took my lords and my lady. Paragraph 21, it's true, Dr. Moss does comment on this. Professor Valenti gives an example of on-off keying in action on the right-hand diagram of figure O. However, it's important to note he is showing here coherent on-off keying rather than non-coherent on-off keying. Now, just pausing there, coherent means the base station has a phase reference to compare the received signal, whereas incoherent means it has no phase reference. And to adopt what my Lord Justice Birss says yesterday, this is how the system knows it's transmitting a zero rather than just having a problem. That's why you need the phase reference. Because incoherent means the base station's got no idea when the signal is going to come. But the point that's made here is that coherent on-off keying has better performance than incoherent on-off keying, but it requires a reference signal, which is 5 lines down. Coherent on-off keying requires a reference signal, a synchronized cosine, to be generated at the base station, which is one of the reasons for the UE signing pilot bits along with encoded messages. And Professor Valenti hadn't mentioned this in the passage we've just seen. Dr. Moss's point is that if the base station has the cosine wave available, then the skilled person will know that BPSK or QPSK produced a lower bit error rate for a given UE transmission power. So if you did intend to design a system which used coherent on-off keying, it would be more efficient to have BPSK or QPSK before the lower bit error rate. So the point to Professor Valenti had said, well, there's a pro of coherent on-off keying, and Dr. Moss is saying, no, there's not a pro. It's got this issue. And then paragraph 22 is Professor Valenti's evidence that a consequence of selecting coherent on-off keying would be that the UE would be required to transmit at 4 times higher peak power. And what Dr. Moss is actually agreeing with here is, well, he's agreeing with Professor Valenti that implementing Leroy in this precise way would be a bad idea for the reasons given by Professor Valenti. Now, having gone through this exercise, my lords and my lady might well ask, what has any of this got to do with the single question about whether the claimed invention is obvious over Samsung? To which our answer is nothing at all, for the following reasons. First, the patent doesn't require coherent on-off keying at all, so none of this matters. Secondly, all of this discussion only arose in the context of Leroy, and that was because of what Leroy talked about increasing the transmission power. Thirdly, none of this material featured in the obviousness case run over Samsung. If it does, then a friend can show you where this features in that evidence. And fourthly, Dr. Moss wasn't saying there was a generally held prejudice against coherent on-off keying, or indeed any form of on-off keying, in all situations and circumstances. He was merely saying it had a particular con, as opposed to a pro, in relation to Professor Valenti's modification to Leroy. That's the long way. Can I then take the court back to what the judge made of this? And that was paragraph 70. I'm not going to read it all out, but in my submission, the judge has just accurately summarised the effect of the evidence that I've gone through in somewhat laborious detail. There's nothing there about any technical prejudice, such as my learned friend suggests. As the judge held, the experts agreed that coherent on-off keying therefore offered no energy advantage over BPSK. Look at the next paragraph. It's utility dependent on issues of noise, cost, and energy consumption. So none of the evidence established any general belief about how on-off keying was not thought to be practical, and the judge didn't find that it did. So that, I submit, is the end of Malone and Friends' island hopping exercise. Now, I promised my lords and my lady a moment ago I would show what we said about this in closing, and that is now amended supplemental. Sorry, yes, supplemental bundle at tab 13. This is an extract from our closing submissions, which we asked to be included. And if my lords and my lady go to page 130, paragraph 264, this is where we set out our case on obviousness over Samsung. I won't read this out in detail. We set out the key issue in obviousness. Samsung doesn't disclose integer 1D. And in paragraph 265, we say nothing in Samsung points towards fundamentally changing this message to one that uses a single bit sent to the physical layer, which is indicative of a request for resources based on its presence. That's the beginning and the end of Lenovo's case. And then we went through the 4 steps. And the on-off keying part, the final step of the primary, we deal with this at paragraphs 282 and 283. And if the court would be kind enough to look at 283, when we're on the 4th step, we say this step relies firstly on it being obvious to use a type of modulation that the extensive searches which Prof. Valenti asked Lenovo's legal team to conduct after a second report had been served failed to show had ever been used anywhere for sending scheduling requests. And then there's a quotation from Professor Valenti's evidence. So we never had a technical prejudice case. The judge was correct when he said that our case was just wouldn't occur in the first place. Now, can I come to Lenovo's next point? It's all about motivation. And the way in which the motivation point is put is a complaint about the judge's finding. If I drew my Lord's attention to the grounds of appeal yesterday, but this is 1B. It's said to be a point of principle that the judge held the skilled person did not have had a motivation to minimise resource allocation and to maximise the number of UEs that a cell could service. And I said that's just a complaint about a holding. It doesn't have any error of principle at all. I stand by that. But my friend's running it anyway, and therefore I will answer it. Now, the first point about motivation, in other words, motivation to go from the prior art to take the step which is required to be shown to be obvious. It doesn't form part of the statutory test. The single statutory test doesn't have anything about motivation. But it may be important depending on the facts of the case. Leonard Friend gave an example yesterday. If you're talking about two things which are equivalent, neither of which offers any technical advantage over the other, such as two pieces of wood held together by either a nail or a screw, then there may be no particular motivation to change the method of fixing, but there's no invention in doing so either. Conversely, whereas here the invention is accepted to offer a technical advantage over the prior art, then it is relevant to consider whether the skilled person, absent hindsight knowledge of the invention, would be motivated to make a change to the prior art, which brings it within the invention. Because if there's no such motivation to make that change, it's difficult to see why the invention is obvious. A skilled person doesn't modify the prior art just for the fun of making modifications. Now, if there is motivation, it's not the be-all and end-all, because it's not the statutory question. But at least it's something else the patentee has to address. Now, the judge dealt with this at paragraphs 165 to 166. I can invite my lords and my lady to go to Core Tab 7, page 105, paragraph 165. Now, we'll be coming back to this in the context of the secondary arguments, but at the moment I'm making a different point. What the judge says here is, to recap, Lenovo's primary case is that it would have been obvious to reduce the size of the 18-bit proposed by Samsung to a 1-bit message, which solely by its presence indicated a scheduling request. On off-keying, the motivation was to minimize resource allocation and to maximize the number of UEs a cell could serve. All the judge is saying here is that this was Lenovo's primary case. Lenovo gave for saying this step was obvious, was because there was a motivation to take it. He's just summarizing the case which was before him. And then in 166, the judge starts by assuming the skilled person would have considered on-off-keying in this context. Now that's the key question, of course. And the judge shortly afterwards held the skilled person would not have done so, absent hindsight. But even on that charitable assumption, the judge points out it was not supported by Professor Valenti's evidence anyway. Now, my learned friend, he quotes, and he took the court to it yesterday, and it is the same evidence which the judge had in mind at paragraph 142 of the judgment. And this is all about going from 18 bits to 1 bits. And at 141, the judge has summarised his findings on Dr. Moss's evidence. And then in 142, he summarised his findings on Professor Valenti's evidence. And the judge has found, as a fact, that in cross-examination, Professor Valenti's argument there was a clear overall incentive to send just a 1-bit message became significantly more muted. Now, the judge was here, was there. He saw the witness, he heard the cross-examination. Unless it's said that this is a perverse finding in some sense, it's not said. It's a finding the judge was entitled to make. And it was entitled, he was not just entitled to make, it was correct. Because, as the judge found, the professor said, the skilled person would be careful how a control channel would be used. There were trade-offs between allocating enough resource to the non-contention channel and avoiding wastage. And you could see the skilled person picking either. And my learned friend took the court yesterday to that very bit of evidence where Professor Valenti says, I can see the skilled person picking either. So the judge's point here is that although Professor Valenti's written evidence had suggested a clear overall motivation, his oral evidence didn't establish any such thing. And that was Professor Valenti's evidence. The judge also found, at the end of para 144, that although Dr. Moss was pressed several times, Dr. Moss maintained his opinion that only with hindsight would the skilled person consider substituting a 1-bit message. So all we have at paragraph 166 of the judgment is a classic example of the judge making a finding of primary fact based on his assessment of the evidence he's been given. My friends are wrong to say that the judge has somehow equated open-mindedness with a lack of motivation. He simply said, Lenovo's case is, it was obvious because there was a motivation. And even making assumptions in Lenovo's favour, the evidential high point is too equivocal to support the submission. So all my learned friend is doing is more island hopping, inviting this court to substitute its own assessment of the detailed evidence for that which the trial judge has already assessed. So I say there's no error of principle here. But in any event, where does the point go if a learned friend is right on this motivation point? Because the judge only made this comment on an assumption which he later rejected as involving hindsight anyway. So suppose the skilled addressee did have an open mind about an 18-bit message or a 1-bit message as a general concept. Lenovo's argument would just fail at the next step, because Samsung's got the 18-bit message, and there's no reason, absent hindsight, to change Samsung from an 18-bit message to a 1-bit message. You need something to change the direction of Samsung, not just to show there's an open mind about it. And that takes us to the very evidence which the judge accepted, para 168, in preference to the evidence of Professor Valenti at 169. So there's just nothing in this motivation point. It's not a matter of principle. It's a misunderstanding of what the judge found. That takes me to another of Melandri-Friend's points about the alleged backward step and the terrible idea. He made submissions about why, in his view, our case of modifying the 18-bit message in Samsung to a single bit was somehow inconsistent with our case on infringement. Now, from the questions my Lord Justice Birss and Justice Falk addressed to yesterday, it may be that the court already appreciates the flaw in this argument, which is this: what Dr. Moss was responding to in that part of his evidence was Lenovo's suggestion of reducing the 18-bit message to a single bit and throwing away all the useful information. Dr. Moss was not being asked to assume a system in which all the useful information was still being transmitted somewhere else. And Lenovo never actually put forward any coherent or specific suggestion as to how all this other information would still have been transmitted. All they mentioned was changing from 18-bit SI message to a single message. Now, I'm going to have to go back through some of the evidence on this to show that that's what the point actually was. I was going to go back to SI and Happy Bit, but I'm not entirely sure if I need to. Melandri-Friend went through it yesterday, and the only points on SI and Happy Bit are paras 52 and 54. Well, let's just do it since I'm nearly there anyway. If I could invite my lords and my ladies to go to paras 52 to 54 of the judgment, page 85. I know the court saw this yesterday, so I'll try and be brief. The point about it is that HSUPA are these two types of information. And the first in para 53 is the scheduling information, which is the 18 bits, which has A, B, and C. And A is the priority level of the highest priority data. And that's the one we tend to focus on, although the SI actually had information about how full the buffer was and how close to the UE. But that, when I talk about useful information, it's that useful information I mean. And secondly, the UE transmitted the simple message known as the happy bit. It wasn't transmitted as a single bit, it was 1 bit out of a 10-bit control signal. But that was a separate signal on a separate channel. And the point about the SI is that none of the three types of information it transmits is itself a request for more resources. There's also a difference. They're transmitted at different layers. Sorry, they're interpreted at different layers. The SI is interpreted at the MAC layer, and the happy bit, or rather the 10-bit stream, is interpreted at the physical layer, and the pattern's about the physical layer. But anyway, that's the background. What was the actual evidence on this point? Now, Melandri-Friend did go to, and this is all about 18-bit versus 1-bit and terrible idea. Melandri-Friend went to Dr. Moss's first report at tab 3, page 48C. My lords and my lady are there. This is.
Did you say 48?
48C. As my lords and my lady will say, this is the first report, and the context is Dr. Moss is considering integer 1D, and he's considering it in relation to Samsung. And at pages 236 to 238, he asks himself, would these differences be obvious? And 236, to develop a system having the integers of integer 1D and 14D the pattern, the skilled person would have to redesign it, the EDCH-SI-like message. And 237, he says, it's my view this change would not have been obvious. The skilled person reading Samsung would not have been prompted to change the design to one effectively falling within 1D. Instead, the skilled person would have considered it sensible for the UE to provide all the parameters within the SI message to the base station and so on. Now that it's a perfectly reasonable point to make about Samsung. The differences wouldn't have been obvious because you have to make all these changes. Now, my learned friend did show you that, but he went straight to Dr. Moss's reply evidence in MOS 2 without showing the evidence to which MOS 2 was in reply. Now, I'd like to do that because it's in sub 4B and it's Professor Valenti's evidence in his first report about obviousness of this integer. And my lords and my lady may have heard reference to 15 lines of evidence in a 70-page report. It's this 15 lines. There's no other passage of the first report. So we see what Professor Valenti was proposing was he's starting with integer 1D, and he acknowledges Samsung discloses the sending of scheduling information over the NCB uplink control channel. And then he says about halfway down, it will be recognized by those skilled in the art that an obvious way of sending a scheduling request is using a single bit of information. And then he says there's a number of known ways to convey it. One of these is on-off keying. He doesn't actually mention the happy bit here. In fact, he didn't mention the happy bit anywhere in the whole 70 pages. But the argument being put here, and this was the only argument, was simply reduce 18 bits to 1 bit. There's not another part of the report where he explains what he's doing with all the other useful items of information. Now we come to Dr. Moss's reply to that, which is sub 4, page 51. And we can see that this is all about the reply to the passage of evidence I've just shown, my lords and my lady. And at paragraph 59, I've discussed above in my first report how I believe the skilled person would understand the reference to an EDCI-SI like message. I'm not going to read out the whole paragraph. But the point Dr. Moss is making in answer is that without any teaching in Samsung as to why such an approach would be useful, reducing the size of the SI message compared to HSUK would have been seen as a backward step in terms of utility, since it couldn't convey any priority information nor uplink transmission power headroom, which could help the ENB to make the best uplink allocation possible for each UE from the limited time for considered resources. I respectfully say there's nothing wrong with that evidence either. There is no teaching in Samsung to do these things, and the proposal was literally going from 18 bits to 1 bit without any compensation as to what you're doing about priority information and uplink transmission power headroom. So that was the system that was actually put to him, and we can see how this was developed in closing by Lenovo at Supplementary Bundle tab 14, page 151. This is the start of quite a long section. In paragraph 210, they say the only issue in dispute in relation to obviousness is integer 1D, which we addressed below. That's absolutely right. Integer 1D was the obviousness case. They weren't saying it was anticipated. And then paragraph 213, they explain the primary case is based on Professor Valenti's view, and that's the reference to Valenti 1, para 135. That's what the evidence I just showed you. Showed my lord already. And then paragraph 217 on the next page, which is page 152, is a heading all about the contents of the scheduling message. And this is where they address the point about why they say it's obvious to go down to 1 bit from Samsung's 18 bits. But they're still not saying, what are you doing with all the other information? And they come to the terrible system backwards step point at paras 222 to 223 and 154. So when Dr. Moss said, well, it's a backward step to throw all useful information without more, without any compensation, that's criticised as being a backward step. And then we go on to terrible system and so on and so forth. Now, the point on this is, this has got nothing to do with on-off keying. This is about the size of the message. And as we discussed yesterday, the claim's got no size limit to the message, and the patent explains different sizes can be used. And it's never been suggested in this case that the scope of the claim exceeds technical contribution, or that the patent is otherwise insufficient, because that would have to be pleaded, there would have to be evidence about it. And when my learned friend said yesterday that the logic which drove the judge to say the reason why on-off keying was not used was that it was thought to have disadvantages and its utility depended on noise cost and energy consumption. That's simply not correct. The logic that drove the judge to say what he did in paragraph 71 was nothing to do with Dr. Moss's evidence about peak power, nothing to do with this last point either. It was that neither of the experts came up with any examples of on-off keying being used in cellular systems that would have been common general knowledge. So that, I would submit, is at the end of any attempt to get this court to make new findings of fact. So can I sum up on the 18 bits to 1 bit point then? There never was any legal purpose in going from 18 bits to 1 bit, because the claim is silent as to the number of bits. There never was any technical justification for doing so, discarding all the useful information which was in the 18 bits. So in both senses, the 18-bit to 1 bit was a pointless modification to Samsung. And the only reason for making the pointless modification to Samsung was Lenovo thought it made the last step of their primary obviousness attack easier. Neither my learned friend nor the relevant 15 lines ever explained what happened to all the other important information which was thrown away. And nor do all these paragraphs of my learned friend's closing. Now, they could in principle have had a proposal about what to do with that. But that would have been another technically and legally pointless modification to Samsung. And Lenovo must have thought that one technically and legally pointless modification was enough. We say that one is too many. Now, our answer to this argument about 18 bits and 1 bits is nothing to do with prejudices or anything like that. It was simply that Samsung proposes an 18-bit message rather than a 1-bit message, and it wasn't obvious out of hindsight to make that change. And that's why it's so the reason why it's a backward step and a terrible system is nothing to do with the invention. It's because they've chosen to exercise it in such a way as to nullify the effect of the invention in their hypothetical example. Now, coming on to my learned friend's secondary case. The secondary case, which is the one that my Lord and my Lady heard about yesterday, I've already made the point that the secondary case wasn't made in the original expert report. I've shown the court what was in the original expert report. my learned friend is saying that although the judge expressly considered the secondary case at 172 to 175, and finding that it ultimately fails for the same reason as the primary case, the secondary case necessarily succeeds. Now, one point which may occur to my lords and my lady is, if this is right, why didn't Lenovo point that out at the time they received the draft judgment, which was on 26th of July last year, and draw it to the judge's attention before it was handed down at the form of order hearing on 29th of November last year, slightly over 4 months later. And I made that point at the hand-down hearing. Now that's an important question, because if my learned friend is right, there is this, that's how that particular sentence, relevant paragraph, should be interpreted, then a number of consequences follow, which are of significant importance. First, the judge should have found that Lenovo won the case. Secondly, the judge could not properly have made the order he did make. And the orders at Core Tab 6, I think we need to go there, but it was usual relief for the patentee. And thirdly, if my learned friend is right, they'll demonstrate the consequences for the judgment are profound. My Lady Justice Falk pointed out, yes, it would mean the judge is contradicting himself, what he is saying elsewhere in the judgment. But it'll demonstrate it's not just the one contradiction, there'll be a whole bunch of contradictions. Now, it's my submission there is nothing in this ground of appeal. But let's suppose I am wrong. If there is any substance in this appeal, in this ground of appeal, then I would submit my learned friend had a positive duty to draw the judge's attention to the last sentence of para 167 before the judge handed down his judgment. Now, can I be clear? I'm not accusing my learned friend of being in breach of duty. I'm accusing him of something else. He never even realised he had a point at all for 4 months. That was why he didn't raise it. They read the relevant sentence the same way we read it. And it was just when grounds of appeal were served, I think the last working day before the form of order hearing, that we heard this point for the first time. So I'm not saying that he is in breach for the reasons I've just given, but I do submit that if there's anything in this point, then my learned friend would be. And that's why I handed up the other authority, which is a decision of this court, ZM. I invite my lord and my lady to look at the ZM. Again, the facts don't matter. It's paragraph 38. I wish to make it as clear as possible that after a judge has given judgment, counsel have a positive duty to raise with the judge not just any alleged deficiency in the judge's reasoning process, but any genuine query or ambiguity which arises on the judgment. Judges should welcome this process, and any who resent it are likely to find themselves the subject of criticism in this court. The object, of course, is to achieve clarity and, where appropriate, to obviate the need to come to this court for a remedy. Now, the whole point of the secondary argument is my learned friend's submission that Samsung actually discloses the subject matter of integer 1D. Not that it suggests it in some indirect way, it actually discloses it. And to start with, my learned friend could perhaps help us all really by identifying where exactly Samsung does disclose integer 1D. If it said the judge made a finding to this effect, it must be an easy job. There's only 5 lines there. Take out a red pen. We'll just underline the words which are said to disclose, not merely suggest, but actually disclose integer 1D. Now, yes, the pages 106 to 107 of the transcript, Milena Friend attempted to do that by reading out the words, sending an EDCH message on a non-contentious resource, which provided periodically, I use an NCSI channel. As my Lord Justice Birss pointed out, that doesn't positively state using the presence of the transmission burst as a scheduling request. But if the judge did make the finding that Milena Friend says, it would be such an easy job to find that in the 5 lines in question. And then Milena Friend could follow that up by identifying where either expert approached the case on this basis. That integer 1D was all disclosed in Samsung. So where does this argument come from? Well, it's all come from a misunderstanding. If one goes to the judgment itself, and I'm going to pick it up at the core, tab 7, page 93. Well, actually, yes. The bottom of the page is where it orients us that we're talking about integer 1D. And then we have 100. Our construction is not enough that Samsung discloses a transmission burst which could be interpreted by the ENB as a scheduling request. And I think this was the point my Lord Justice Birss was making yesterday when Milena Friend was advancing the secondary case. It's the point about how the ENB, which is at the receiving end, actually has to interpret the transmission burst as a scheduling request. And then we go to 124, which is the beginning of the section on Samsung. Now, if Milena Friend is right that integer 1D is disclosed in Samsung, then the judge has gone wrong by para 128, because the judge says the issue inventive step over Samsung, and then he says what the inventive step. And that's consistent with Milena Friend's closing that I took the court to just a moment ago. That's what they were saying. It was an obviousness issue over 1D. They weren't saying claim 1D was actually disclosed. I mean, if they were saying it, then where did that closing submission say so? But anyway, if Milena Friend is right, the judge has already gone wrong here. Because if integer 1D is actually disclosed in Samsung all along, this paragraph is wrong. And then, of course, all the other integers, the judge says, all the other integers are either disclosed by Samsung or obvious variations. So integer 1D was the only one that mattered. And then the judge goes through Samsung inventive step, the arguments, and he sets it out at 121 to 133. If Milena Friend is correct, then this whole section is all wrong as well. Because if you look at paragraph 131, this is Lenovo's primary case. It was obvious to implement option B by making the EDCH-like message a 1-bit transmission burst, the presence of which communicated a scheduling request, rather than an 18-bit message encoding the scheduling request. Well, if the judge already accepted that the bit about the presence of the transmission burst, the presence of which communicated the scheduling request, the bit about the point about going from 18 bits to 1 bit never mattered at all. The secondary argument would only be needed to cover integers which were agreed to be disclosed or obvious. And then paragraphs 141 to 158, where the judge considered the expert evidence on the primary case. Well, paragraph 141 would all be completely irrelevant, because if Samsung already disclosed integer 1D, none of that would have mattered. And the whole primary argument would be unnecessary anyway, because they never needed to do 18-bit to 1-bit. And the secondary argument was bound to succeed. They would never have needed to rely on the secondary evidence, which has not been pursued, but was relied on below. That would have been unnecessary. And 165 to 171 is also all wrong, particularly 169 to 171. Because 169, not persuade the skilled person, would have considered replacing the 18-bit messages. That can't stand a Malone Friends argument is right. And what about para 171? I think the skilled person's mind would have stayed with what Samsung was recommending, and it would not have occurred to them to think further. Well, if they're sticking with what Samsung's recommending, and the judges found that it actually gives you 1D, then that would be a conclusive reason why Lenovo won the case. And so on, 172 to 175. They would also be wrong as well. The judge never needed to consider the secondary case at all because it was all disclosed. Integer 1D was also disclosed in Samsung. So how did I try and get this argument off the ground? Well, by misreading in the submission. We know by this stage very well that in HSUPA you have the SI, which is 18 bits, and the happy bit, which is part of the 10 bits. And these are the two items of information used by the node B in HSUPA to determine the maximum power grant to be allotted to a mobile. And then if we look at 165, the primary case is as set out here, but the key question is the point about 18 bits proposed by Samsung to a 1-bit message, which solely by its presence indicated a scheduling request. So the key words are solely by its presence indicated a scheduling request. That's what the judge was actually considering. Now we come to para 167 and do the exercise of parsing it in some detail. The judge says, I think the starting point for a skilled person considering the EDCH SI-like message of option B, section 302 of Samsung, do you think of the familiar EDCH SI message of HSUPA? Yes, that's not disputed. That was an 18-bit message containing scheduling information and without a bit identifying the message as a scheduling request. That's correct too. All it contained is scheduling information of the three types A, B, C. Judge goes on, that function was provided by the happy bit sent on the EDP-CCH. That's right as well, because the SI and the happy bit are sent separately. And it's different signals on different channels. What we know is that both of these messages in HSUPA, which is the 18-bit SI and the 10 bits containing the happy bit, had to be decoded. Lenovo doesn't suggest the contrary. So far, so good. And then we come to the final sentence. Option B indicates that its proposed message is not the same. And that it's not the same because it's EDCH SI-like message rather than EDCH SI message. Now, why is it not the same? And it can only mean not the same as HSUPA. The reason is, as my Lord Justice Birss pointed out, in HSUPA the SI didn't have a bit identifying it's a scheduling request. It was a 10-bit field containing the happy bit, which had that. But in Samsung, sending the EDCH SI-like message does serve as a mechanism for asking for uplink resources. And if you stop there again, the judge is correct. Sending the EDCH SI and HSUPA was not a mechanism for asking for uplink resources because that was done by the happy bit, sent on a different channel as part of a different block. But what the judge is not saying here is that sending the message equals using the presence of the message itself to indicate a scheduling request. That's what he's considering. That's the question he identified in para 165. The point was about solely by its presence. So in 167, he's not using the language of para 165 when he set out the question he had to decide. He's not talking about presence at all in 167. This paragraph's got nothing to do with presence. He does say sending the message, singular, because he does envisage Samsung bringing the functions of the two different messages of HSUPA into one. And it's true that they were both sent in HSUPA because a message is no use unless it's sent. But neither of these two messages in HSUPA was interpreted by reference to the presence of the transmission. They both needed decoding. That's back to paragraphs 52 and 54 of the judgment again. And then the closing words are, although that could be done by a signal within the message. And that's true too, because that was the position of both sides. Neither side was saying that Samsung disclosed detecting the presence of the transmission burst as a request for scheduling resources. So why does the judge say although? Because he was rejecting Lenovo's case as set out in 165. Because 165 is where they said it would have been obvious to reduce the size of the 18-bit proposed by Samsung to a 1-bit, which solely by its presence indicated a scheduling request. And all the judge is doing is pointing out Samsung doesn't suggest a message which solely by its presence indicates a scheduling request. He says that to be done by a signal within the message. But the point about what could be done is a theme which runs through the judgment, because what could be done isn't enough. It's what's actually done that is important for the construction of the claim. Now that's quite a lot of parsing of a single sentence of a rather long judgment. Isn't there a much simpler way that if the judge had meant to say Samsung discloses integer 1D, which is what Appellant and Friend wants to read this, he would have simply said so in those, well, 3 words. Much clearer and simpler terms. But that wasn't the issue he was asked to decide. Both sides' case was that integer 1D was a matter of obviousness, not of anticipation. And the issue of novelty, the issue of whether integer 1D term, if he had decided that, he would have gone beyond what both sides were asking him to determine. And he would have had to rewrite most of the judgment as well, in the respects I've indicated. So the friends just simply misunderstood what the judge has said here. And that only leaves paragraphs 172 to 175 of the judgment. And Appellant and Friend's problem is that these paragraphs are a stark rejection of this secondary case. The way he puts it in his skeleton argument is he says, well, they don't displace the conclusion that the judge had made about how integer 1D was disclosed. But if he never reached this conclusion in the first place, that all stands. Now, what the judge does here in 172 to 173 is he considers the argument raised by Professor Valenti in his second report. It is actually correct, as the judge indicates here, that Professor Valenti's, the only document upon which Professor Valenti relied as supporting the secondary case was the patent itself, paragraph 37. And that's why the judge says what he says in paragraph 173. Appellant and Friend suggests that, oh, that was never their case. But if Professor Valenti ever relied on another document in support of his secondary case other than the patent itself, he can show it to my lords and my lady. Appellant and Friend also said that the quotation was somehow incomplete. He took the court to that yesterday. My submission, there was nothing incomplete about it. All that actually happened was that a couple of confirmatory sentences had come out without being indicated by 3 dots, but there was no change to the substance of the evidence. The point isn't really the narrow one of is this a correct quotation in any event. It's the substance of it. That in HSUPA, you had to decode the signal, and Samsung, on Professor Valenti's view, is doing something different. And there's just nothing which teaches that in Samsung. I sense I'm starting to repeat myself now, and I'll try not to do so. So the actual answer, as the judge actually says in paragraph 174, is that you do change the EDCH SI-like message in option B of section 3.2 from the EDCH SI message with which he or she would have been familiar. And in particular is this difference indicated by the judge in the last sentence. So paragraph 175 is correct. The secondary argument does still require the skilled person to focus on the uplink message of option B and to have considered on-off keying as a substitute. So we're back to the same as the last step of the primary case. Now there's just one or two other points. I've gone slightly over my I've trespassed on my Lord and my Lady's patience enough. These are all my solutions. Thank you very much.
Thank you very much, Mr. Campbell. Yes.
I'll just Lord and my Lady briefly in reply. My learned friends started this morning by showing you a decision of Mr. Justice Arnold in the Dyson case, where Mr. Justice Arnold had commented on the principle in Pozzoli and had suggested it should be amended by reference to to suggesting that the patent need only make it plausible that the invention was sold with prejudice. Now, in relation to that, just a couple of short points. The first one, of course, is that's only a first instance decision. My Lord and my Lady is still bound by Pozzoli. Obviously, the Bristol Airplane Company case remains good law. So that's the first point. But the second point is it isn't in any event an answer to the point, because there's simply nothing in the patent itself that says anything that would make a skilled person who thought that on-off keying was a bad modulation scheme because it has the excess peak power issues described by Dr. Moss, would change their views of that. And in any event, and I'll do this without handing Warner Lambert up, but I do have it with me if you need it. As my Lord will recall from the Supreme Court's decision in Warner Lambert, one of the key factors about plausibility is that plausibility has to arrive from something based on the disclosure of the patents. Something can't be plausible based on the common general knowledge alone. And there's nothing in the patents at all about this, so there's nothing that can render it plausible if the skilled person was operating under the view that on-off keying was a modulation scheme with significant drawbacks. So that's the answer to that point.
Essentially, just right now, I'm more worried about what the law is than about what the answer to this case is. Let's make sure I've not misunderstood something. The point that the Dyson case reveals, which I hadn't appreciated before, I'd forgotten, is that you could read House of Lords in Connor and Angiotech as overruling that bit of Pozzoli, because that's what Mr. Justice Arnold's doing in Dyson. He's taking a submission where someone takes a sentence out of Connor and Angiotech and says that that's inconsistent with Pozzoli, and he's proposing a way of reconciling them. So I take your point that it's a first instance decision, but it's a first instance decision grappling with a submission which until I saw it hadn't been made in this court, that Pozzoli isn't right anyway because there's a House of Lords authority that says so. What I don't want to do, because neither side has spent a lot of time arguing about this point, is compound any problems by then deciding with great aplomb a point of law which hasn't really been the focus of your submissions, except as you have just done. But it seems to me it does arise in this case. You're making a case based on Pozzoli, it's fine, and I haven't detected. Well, the fact that you're making the point that it was a first instance decision makes it sound like you're saying that you don't agree with it. I'm not trying to push you either way, but ultimately this court will have to write a decision which grapples with that point of law. And currently I'm concerned because I can foresee that it has to say, and there is this query, and at the moment, I'll be absolutely blunt with you, I'm attracted to the way in which Mr. Justice Arnold dealt with it. But what I don't want that to do is if you've got submissions to say why that's not the right approach. I understand why you say you win anyway. That's a perfectly legitimate submission from you, Mr. Instone, I get it. But before we get to that, I need to know whether there is actually any reason for saying that Mr. Justice Arnold's approach isn't right.
Well, I can see the force in the point that it's based on the decision in Connor. So my main response is the one I gave second,
right,
which is that if one is considering plausibility, as the Supreme Court made clear in Warren Lambert, plausibility has to arise from the disclosure of the patent. You can't get plausibility from this common general knowledge alone. And there's nothing in the disclosure of the patent in this case which would make something plausible that wasn't otherwise already known and obvious.
Okay.
That's the answer to that.
Thank you.
Sticking with Pozzoli is a case about known or obvious techniques thought not to work or to be practical in circumstances when the patent comes along and claims that technique without explaining why what was thought to be not to work or not to be practical was in fact wrong. Now, on-off keying was a known technique, and you've now seen twice Dr. Moss's evidence about why the skilled person would think there would be downsides with on-off keying. I'll come back and deal with the context points about that in a moment. And we say that the judge's findings that on-off keying was not frequently used and therefore was not at the forefront of the skilled person's mind wasn't an arbitrary finding made in a vacuum. It was a finding made due in the light of the issues with it, which have been highlighted by Dr. Moss. And what InterDigital's case seeks to do is to frame the evidence or the position as, well, you wouldn't think about this common general knowledge technique because it hasn't been used in cellular systems, and frame it at the level of the skilled person just wouldn't think about it. To sidestep the reasons why the skilled person wouldn't think about it and the reasons why it wasn't used. And those reasons were because it was perceived as a matter of common general knowledge to have technical shortcomings. And it wasn't used because generally BPSK was a better technique and had lower power requirements and lower peak power requirements. And it was those reasons as to why it wasn't in the forefront of the skilled person's mind, which we say that the patent, if the patent was to come along and claim transmission burst and on-off keying, it would need to dispel, and the fact that it didn't is the vice. And that's why we say the lack of teaching of any utility or any teaching about the benefits of the presence of the transmission burst is relevant to this case. So I'm now going to get into the more just picking a few more disparate points if one wasn't ready. So going back to the judgment, so that's Core Tab 7, paragraph 62. And this is the point about the judge's reference to the Holmer and Toscala book. And my other friend made a point that, in contrast to what was said in addition to what was said in 62, in paragraph 64 of the judgment, the judge also refers to other documents which were never suggested to be common general knowledge. The implication of the submission that was made was there's no difference between those documents and the textbook that the judge referred to in 61. But of course, the difference is that in 62, the judge expressly records that Dr. Moss accepted it is still what the skilled person was known at the priority date. And we say that's plainly a finding by the judge that the contents of the book were common general knowledge. And we can ask the forensic question, why else would the judge, in his judgments in the common general knowledge section, be saying that? The skilled person is a notional hypothetical construct. my learned friend yesterday explained the concept of the common general knowledge and the fact that for an individual real person, they may have things that they know, but just because they know them doesn't mean that they are common general knowledge. But the skilled person is different. The skilled person only knows the common general knowledge. The skilled person doesn't have a level of knowledge that's something other than the common general knowledge. So we say that the judge, when he recorded Dr. Moss's acceptance that the book distilled what the skilled person would have known at the priority date, that can only be because he was finding that the book recorded what was common general knowledge. And as I took you to in opening, obviously Dr. Moss had said and given evidence that the HSUPA standards formed the common general knowledge, and therefore the acceptance that the book distilled what the skilled person would have known from the standards was merely saying that the book was a subset of the skilled person's common general knowledge. A point that my learned friend made yesterday was that the Professor Valenti, he said, hadn't referred to on-off keying in the common general knowledge sections of his reports. Now that was a carefully worded submission, because as he showed you this morning, Professor Valenti had explained, given evidence that on-off keying was a well-known, probably one of the earliest modulation schemes. And so the submission is a submission about to the form rather than the substance. Professor Valenti was being very clear, and it was common ground that on-off keying was a well-known modulation technique. The point that was made was that it wasn't in the common general knowledge section of the report, but ultimately we say that goes nowhere. Yesterday, my learned friend made a point from paragraph 36 of his skeleton that this was the stepwise criticism of the stepwise nature of our case, and he said that there's a preliminary step in our approach, which is to decide that the message sent in option A of Samsung is different from the message sent in option B. Now, our primary answer to that, is that the judge didn't draw that distinction. There's no part of the judge's reasoning in the judgment that there was an initial step that you had to read Samsung as allowing for an option of having something different. And although my learned friend does have a responder's notice, he doesn't have a responder's notice on this point. Now, just picking up a point that was made this morning, which I think actually I should have dealt with about 3 minutes ago, which was the point my learned friend took you to Professor Valenti's evidence in relation to on-off keying and the power issue. So that would be supplemental bundle tab 5 and page 56A. Page 56A, and it's the paragraph 55. And the point that was being made was that this was all in the context of the Leroy prior art rather than the Samsung prior art. And it's true that Professor Valenti came to the issue of on-off keying and the power issues associated with it when he dealt with Leroy, because he dealt with Leroy first in his report. If my lords and my lady turn on to paragraph 106 of Professor Valenti's second report, when he does deal with Samsung, you can see just over the page onto page 61, he refers back to what he said about on-off keying in the Leroy section. So insofar as the submission was one, well, I'm island hopping because I'm plucking evidence that was given in relation to Leroy, and I'm now in this court for the first time planting it into Samsung. That's not correct. It's simply an artifact of the fact that Professor Valenti dealt with Leroy first, and then having dealt with the substance of it, rightly didn't feel the need to write it all out again. He referred back to what he'd said. So, moving on to another point made this morning, which is it would be a terrible idea to get rid of all the scheduling information points. And I think one of the friend was going as far as saying that this wasn't what wasn't suggested by the witnesses was Professor Valenti, was that one obvious thing to do would be to get rid of the information on the non-contention channel, but send it on the data channel. Because obviously, option A of Samsung was to send the information with the data. And just for your note, that was paragraph 111 of Professor Valenti's second report when he was dealing with replying to Dr. Moss. He's made precisely that point. So that's supplemental bundle, tab 5. Page 61A, paragraph 111. You see there 5 lines down. Another obvious way of implementing the signalling on Samsung's proposed channel with the UE only sends scheduling information along with the data when uplink resources have been allocated, as described in section 3.2a. Now, so that's just the impression he was seeking to give, was that this was all being concocted after the event, but it was part of the case. Now, my main answer on
is that the same as the way LTE works? That we've been talking about.
Yes.
Well, is it? It says scheduling information along with other data when UL resources have been allocated.
That's how LTE works.
That's 328.
Yes. So both. So Samsung suggests in option 32A that the EDCH-SI-like message can be sent along with data. It also suggests in B that that a message can be sent on the non-contention channel. So Samsung has both options, and what Professor Valenti here is explaining is that his way of bringing the non-contention message down to a single bit, which was common ground for the trade-off between the wasted space and the capacity of the channel. In answer to Dr. Moss's suggestion, well, that would be terrible because you would get rid of scheduling information, his answer was, well, you wouldn't necessarily because you could do it this way. So to answer my lady's question specifically, that is how LTE in fact works. There's a short burst on the it's called the PUTCH, the primary uplink control, the physical uplink control channel, and then there's an allocation, and then where the UEs then send more information when they get their uplink allocation on the data channel. Now, my Lord Justice Birss put the point to me yesterday that the patent doesn't exclude sending that kind of information on the data channel after an allocation has been made, and that's right. It doesn't. But what the patent doesn't do is teach the skilled person that if they choose the first option in paragraph 37 of the patent, which is just the burst whose presence indicates the scheduling request is being made, so without taking the later option of adding that information into the burst itself and sending it on the non-contention channel. So if you take the first option, just the burst, the patent doesn't teach the skilled person how to send the scheduling information at all. And it can only be a terrible idea if the skilled person the that information can only be sent if the skilled person already realises that an obvious way to do it is to put it on the data channel. So it's unless it's common general knowledge that you can send the information on the data channel, then the patent does cover, does claim the terrible idea. But of course, if it was common general knowledge to send it on the data channel, then the whole prejudice about not sending the scheduling information data just melts away, because the skilled person knows there's an alternative way of doing it.
This isn't the prejudice that your case on appeal is about.
The
prejudice is about on-off keying.
It's also modelled about going down to also the prejudice of going from 18 bits to 1 bit, because what Dr. Moss's evidence was is you wouldn't.
Well, I know you have a point that Dr. Moss's evidence was that that was a terrible idea, but that's a different piece of your appeal. It wasn't. I don't recall your appeal on prejudice was related to that. I know you're making a point about the terrible idea. Maybe I'm misremembering, or correct me if I'm wrong, but.
No, my lord, it is part of the appeal.
I know it's part of the appeal.
Is that in relation to the evidence as to why you'd want to go from 18 bits to 1 bit? The answer to that was you wouldn't want to throw away scheduling information data.
Yes.
That was the barricade that was put up, and we say that is another way. That is another fixed way of thinking. Dr. Moss's evidence was the skilled person would not want to get rid of that data. For that reason, although they knew about the trade-off, they knew about the trade-off between lowering the amount of information on the non-contention channel and therefore increasing the capacity as compared to the information, they'd want to stay transmitting the scheduling information, and so they wouldn't want to reduce the size of the message on the non-contention channel. Now, if that's the way of thinking, we do say that the patent needs to dispel why that way of thinking, must have the scheduling information, and why that was wrong. And it doesn't do that because it claims sending a single burst without the scheduling information, and it doesn't provide the skilled person with any teaching how, if they take that option, they can subsequently provide the scheduling. That's the point.
Okay.
So then, turning to the secondary case, the first point my learned friend made was take your lordships to the case of ZM and JM. If you just go back and see what that case decision says, and that's in paragraph 38. The Court of Appeal is making it clear that after a judge is given judgment, counsel have a duty to raise with the judge any deficiency. And my learned friend turned that into an obligation to do it before the judgment's handed down. And that isn't, in respect, what the Court of Appeal is saying in that case. And of course, we did raise it with the judge when we came back for the permission to appeal hearing. And the judge didn't see fit to make any changes to his judgments in the light of that submission. So he accuses me of being slow, and perhaps judgment came down on the 29th of July, those kind of things. But we did, at the end of the day, we did raise the issue with the judge. We haven't sat on it and saved it up purely for this cause. The judge was given the opportunity, and he didn't take it. Now, there was another suggestion as well this morning in relation to this, that my other friend slightly backed off the case wasn't a novelty case point, but he did say this morning that no expert said that sending Samsung's 18-bit message would end up fulfilling the requirements of the claim. And again, that's not right. I took you to it yesterday, so we won't get back to it, but it's supplemental bundle tab 5, and paragraph 102 of Professor Valenti. He had, when he dealt with this issue, having seen what Dr. Moss said, he went through and he said, when you send that message, as described by Samsung, that meets the requirements of the claim.
Paragraph 102.
106. No, I just said 102, didn't I?
I think it is 102 that you
Yeah.
rely on.
Yeah, this is 102. That's right. My other friend also had a period this morning where he took you through the judgment and pointed to various paragraphs of the judgment and said, well, if we were right about paragraph 167 and what the judge found, then all the sections in the primary case would have been irrelevant. But that overlooks the fact that we were running two alternative cases. We were running the primary case and we were running the secondary case. And the judge recognised that and he needed to deal with those. And that's what he did. So it's not inconsistent with our case in relation to the secondary case on appeal that the judge dealt with our primary case at trial. That's what he
Well,
had
the point, it is a bit odd, isn't it? Isn't there a point? Doesn't Mr. Campbell have a point that if the judge thought that in paragraph 167 he was reaching a conclusion that integer 1D is disclosed by the prior art, if that's what the judge thought he meant when he said what he said in 167, it is a bit strange that the rest of the judgment proceeds on the basis that the prior art doesn't disclose integer 1D. That's a brief way of putting Mr. Campbell's point.
That's the point, but we say it is the consequence.
You know, I understand. You say that is what this means. I understand.
And just going back to my little friend's submissions on 167. What he relies upon is he says that the sentence where it says option B indicates the proposed message is not the same. He relies upon that to say, well, what the judge was doing was rejecting the submission that it would be the same 18-bit message with no bit in it about the scheduling request, and therefore suggesting that what the judge was actually finding was that the message, if sent on Samsung's channel, would have a scheduling request indicator within it. We say that's not what the judge was, plainly not what the judge was saying, because he explains why it wasn't the same. It wasn't the same in that it's the sending of the message that serves as the mechanism for asking for the request. And then, just to compound that, we have the last clause where he accepts, although, of course, you could always do that if you wanted. So, we say it's clear that the judge was finding there that it's the sending of the 18-bit message on Samsung's channel that's the way that the request is being made. And as I explained yesterday, Dr. Moss's evidence was that the way this would be implemented was that the message would only be sent when the UE had a request, was making a scheduling request. It wouldn't be sent if it wasn't. So, and to that, my Lord Justice Birss put the point to me, well, what Samsung's talking about is the sending of the message, and what the patent's all about is about how the message is interpreted at the base station.
Mm-hmm. Well, not all, but that's part of it.
But, of course, the base station knows that the message is only being sent when a scheduling request is being made. Mm-hmm. That's the way it will be implemented. And what it has to do is it has to, in the particular allocation on the non-contention channel that's being given periodically to each UE, the base station has to detect whether there's any energy, any signal being received in that period from the UE. And if there is, it has to then go in and demodulate the bits within the message to work out how much data the UE's got to send, what the priority of it is, and so on and so forth. And obviously it will only do that demodulation task if it detects that there is something has been received from the UE. So the first step that it will have to do in that process is detect whether there is a message that's been present.
Right.
And once it's done that, it has detected the presence of the message. And because there's nothing in the message that says, I would like some data, or I don't want any data, it is the presence, it's the detecting of the presence of the message that determines that the scheduling request has been made.
Right.
Because
That's not a point that the judge grappled with. You didn't put that to the judge, did you? As you've just articulated it. I understand. I mean, the words detecting presence of the message, I know that's all over the place, but you're putting a more, dare I say, sophisticated way of analysing that, which I don't recall reading the judgment.
well, the argument that was put to the judge was that the sending, as Dr. Moss had explained, you send the message when you want to make it, the UE wants to make a scheduling request, and sending that message would fulfil the requirements of the claim. Now, I was right that I've perhaps explained it in more detail than we did in closing, but it follows from how the fact that the message is only sent when the UE has a scheduling request to make, that the first, and from the fact that there is no bit in it saying I have a scheduling request, the first thing the base station's got to do is ask itself, is there something there? And once it decides there is, it will go and demodulate. Because if there isn't anything there, there's nothing for it to demodulate.
Well, I understand. I mean, I understand that the base station has to decide there's something worth trying to demodulate, and then demodulates it, reads the bits. I mean, there's common ground. But the point that you're putting is that process is inherently and necessarily using the presence of the burst as an indication that there's as an indication of a request for scheduling.
Yes.
And I think what might be said against you is that that's what HSUPA does, all of those things, and no one's ever suggested that is inherently a request for scheduling. It isn't.
Well,
What's been taken as the request for scheduling is reading the bits and thinking about them, and you could have coded your system to to make a decision that earlier in the process of going through those steps you've just given to me, you're going to say, right, I now know there is a scheduling request and I'm going to act on it in that way. You could code your receiving system like that, but there's no suggestion that I recall that anyone's ever suggested anyone has ever done that or thought of doing that.
well, I think we would say, my lord, it's the inevitable consequence of sending the 18-bit message on Samsung's non-contention channel.
Why is it not the inevitable consequence of doing it in USB HSUPA either?
Because in HSUPA, the scheduling information is sent at the MAC layer, and you have to decode the message to even know that there's anything there, along with the data, because it's in a MAC layer packet, along with data. So the packet has to be entirely decoded to work out whether there's even scheduling information there, because there may not be in some situations. It's a different situation to a physical channel where the UE has been given a specific time code and frequency resource to send scheduling information on that, and that's all it's ever going to send there. There is a difference.
Okay.
Well, I'm not going to interrupt too many times, but that was a new argument.
Okay.
My lords and my lady, unless I can assist any further, those are my submissions.
Thank you very much, Mr. Hinchcliffe. Is there anything else you want to say, Mr. Campbell? I think you're right that there is certainly a new nuance in the argument. You can have a minute.
Well, no, funnily enough, I was just going through the same thought process as my lord was, that if that were right, we would have a case on HSUPA, but they never had that case, or rather they did have a similar case, which they dropped before trial, about reliance on one of the HSUPA documents. But it would be a new argument, and there was no evidence to support this new argument. It's something my learned friend's putting forward for the first time. That's all I wish to say about that.
Okay. Thank you. Particularly speaking, Mr. Hinchcliffe, I'll give you 30 seconds of reply if you really want. I don't think you need. Very good.
Thank you.
Very good. Well, we will rise and reserve our judgment. I hope that doesn't come as a surprise to you. Drafts will be circulated in due course to those counsel and solicitors whose details were supplied before the hearing, so they can draw our attention to any typographical or minor factual errors and agree a draft order as far as possible, and if they don't, file written submissions so that an order can be finalised at the same time as the handing down. Circulation to the parties or to any other person for the purposes identified in Counsel General for Wales case will be the responsibility of the solicitors. Any such circulation is for those purposes only, and any other publication may be a contempt of court. I expect you're all very well aware of that, but in circumstances that I expect you're aware of, we've taken the view in the Court of Appeal that we need to emphasise it at the conclusion of hearings. I hope it doesn't come as a surprise to you that it is unlikely that you will get the reserve judgment this side of Christmas. It will be in 2023. Thank you very much for those making the oral submissions and for those sitting with them and behind them for the preparation of this case. Appreciate it.
All right.